Why not get a mechanic before you bought the car?
You know, I trusted it. I trusted the purchase.
Yeah.
Look, I am guilty of making a fast decision on the purchase, and I'm guilty of making a poor purchase. I asked in good faith for my money back, and I was refused the money back. And if you have 3 or 4 other purchasers, just take it back, man, and sell to them for more money. No problem.
Sir, what did you want to say?
I wanted to add that my wife's uncle is a mechanic.
Right.
And he gives maintenance to all my vehicles. I bought the engine that I swapped, and I paid $1,850 for just the engine. Plus the catalytic converters, I paid initially like $1,000 plus labor, right? So that added to $3,750 that I spent from my pocket just June of last year. So in 6 months, I'm selling the vehicle for $3,800, which is more than a fair price because I checked on Kelly's Blue Book prices, and those vehicles go between usually like $4,000 or $5,000. So in average, even the interior is good. I checked the tires. I even told him the minute that he drove the car that, you know, the tires are a little worn out, but they're still good. You know, you can see the tread. And I told him, I gave him tips because I have bought cars on the streets and they done me dirty, other people to me. I wouldn't do that to somebody. And I let him know
Mr.
that.
Goki.
Yeah.
We, as an arbitration court, have what we call equity jurisdiction, which means that if applying the law results in an injustice, we can remedy that if a remedy exists that's acceptable. So your offer to accept $1,500 or for the defendant to give you $1,500 implicates that conflict between the law and equity. But you have no evidence that the defendant deliberately or knowingly misled you about any of these issues. Am I correct?
I mean, I couldn't see how the running of the motor like that could be not noticed.
You couldn't imagine that it drives okay today and you get up tomorrow morning and you turn on a 15-year-old car and it doesn't even start.
Well, the broken rack and pinion situation with what I was told was a fluid situation. Steering fluid situation.
Yes, but what you're told, and even this diagnostic test is hearsay. We accept it for what it is, but we don't know this mechanic. We don't know whether or not he might be overreaching. What did you want to say?
I would like to let the judges know that I have the payslip here and he never came to pick up, and
You have the you have the title for it.
Yes. Also that he got a ticket while he had the vehicle.
And you paid for that
And
ticket.
I paid for the ticket, and I have the evidence with me as well.
I have nothing further. Are you good, Judge?
Yeah, I'm good.
Are you good?
Yes.
All right, we'll excuse the parties while we deliberate in this case. Thank you both very much. All right, we've reached a verdict. Mr. Goki, you raised some important issues that we needed to address. We're talking about a law that is time-tested and provides, even within itself, exceptions to the application. The law is that when you have an opportunity to investigate, to inspect, to test an item that you're purchasing, the burden falls on you if in the future something goes wrong with that particular item. We ultimately concluded that to require the defendant to pay you $1,500 would not be fair to him under the circumstances. So as a legal matter, you're not entitled to unwind this deal or return of the money that you're requesting in your complaint. As far as your cross-complaint is concerned, there's nothing extraordinary about the stress that was placed on a deal where there was a dispute, and therefore you're not going to prevail with respect to emotional distress or for lost wages. This just goes with the territory. But you did pay for a ticket, and we feel that we can construe the complaint broadly so that you are entitled to be reimbursed for that payment of $75. The complaint is dismissed. The verdict on the cross-complaint is for $75 in favor of the defendant.